Okay, now that we've heard from our witnesses, we're going to consider a few matters before moving forward with our discussion for today. We're going to begin with the minutes from our July 2024 meeting. I move to put those into the record. Will somebody second approving the minutes?
Second.
Thank you. All in favor? I see raise of hands. Is anybody opposed? No. All right. The minutes are approved for the July meeting. Thank you. Next, Tom Nosowitz will provide brief updates on legislation that our committee has recommended and updates on 2024 crime data.
Yes. Okay. So as most of you all probably know, the legislative session ended last weekend, and we had 4 bills that were based directly on Penal Code Committee recommendations that were passed by both houses and are now awaiting action by the governor, including the one from Assemblymember Bryan about pre-arrest diversion, and then one on post-conviction procedures from Assemblymember Ting. Senator Minjavar was the author of our competency to stand trial reform bill, which we also tried last year and were able to get done this year. And then we also did some cleanup on some of the license suspension recommendations and the transportation omnibus. And there are also 2 other bills here, one around reforming juvenile restitution and mandatory review of bail conditions that were sort of in line with things we've recommended, and we tried to assist the authors and the sponsors of those bills through, and those were also signed this year. So I think all in all, pretty great results given everything else that's going on right now. So I don't know if anyone has any questions about those, but I would move on.
Any questions? I'll just say one comment. Kudos to Tom, Joy, Rick, Natasha, our team for getting these bills done. Assuming that the governor signs these 4 bills, which I'm hopeful for, they will mark 20 pieces of legislation that this committee has recommended, I think, in 4 years, which is really extraordinary. And I really appreciate everybody's hard work, especially our staff who are really the best in business. So thank you.
And Natasha and Danica and Lizzie too, especially.
Oh, yeah. Yes.
And I know you
mentioned I said Natasha, but
I know.
Danica,
I just wanted to make sure.
No.
We can't say it enough, honestly.
Agreed.
Okay, mid-year violent crime data. So I won't get into the details, but we're able to look at the 8 largest cities across the country, including 8 large ones in California. It's just violent crime. Last time we were able to look at property crime as well. Those statistics have not been updated yet, unfortunately. But we have these from the Major Cities Chiefs Association. And we can see, this is comparing the first 6 months of this year to the first 6 months of last year. Overall, a 3% drop in violent crime, 9% drop in homicide, 16% in rape, a slight increase in robbery, and around a 4% drop in aggravated assault. The cities outside of California had bigger drops in violent crime, though I will say I think some of that data is not reliable. We saw like a 40% drop in one city that doesn't seem right, but we just kept it in there for sake of comparison. And on the second line here is the 3 jurisdictions within those 8 that are just in LA County, which is the LAPD, Long Beach, and then places that the sheriff patrols there. And you can see the violent crime drop is, it drops barely, less than 1 percentage point. But again, you see a pretty big increase in robbery year over year. So we'll continue to keep an eye on this as we do, and hopefully when we come in October, we'll be able to have more information about property crime in more cities. So I think this is, helpful news and a little bit different, obviously, than we sometimes see people running for president sometimes say. Okay, any questions about the crime statistics? I think that's it. And then we're going to do new business or more follow-up on the habeas stuff, Mike, or do you want to go into the follow-up from July?
I'm not sure what you're asking. So
what? I think let's follow up if there's any more discussion we want to have about what we heard from our presenters today, mostly on the compensation and the innocence, habeas, and discovery issues that we spoke about. I mean, we kind of talked about them a lot in the moment, so I don't know if there's much more to be said, but
yeah, let me try to summarize here and see if anybody has anything to add.
Right.
The summary here is going to be our business here is what we are instructing staff to continue to develop in terms of proposals. Going in order of the panels that we heard today, is the idea to modernize the compensation structure and regime for people who are who are exonerated from crimes that they've committed. So this is the financial compensation statute. And we talked about adjusting the amount of money for inflation, proposal to expand compensation to include time you spent on parole or probation or sex registry, a look back for people who were compensated under the old regime, which was capped at $10,000. So that if you would get more money under today's regime, that you could come back. Compensation for child support and other related fees. And I would like to add to that able to compensate for time spent in jail after exoneration without going before a judge. Are there other items in the compensation conversation that either came up in our conversation or were in the memo that we would like staff to emphasize in their recommendations to us around compensation?
Yeah, I mean, yes, child support was one of them, but I think there was also a broader conversation about compensation for families. So, yeah, I don't know what that would look like, but I'd be interested in what staff's able to find in terms of other models or models that might be feasible.
Yeah, particularly in other states. I mean, yeah.
I think we heard no other state does it, but we'll look a little bit more.
But I think it's to reinforce Professor Ocean. I think it's worth it for us to put it forward because obviously, in most cases, not all, the person incarcerated either was or likely would have been a breadwinner for the family, and the family then was denied that income during that period, which of course, not only set them back for the period of time the person was incarcerated, but full into the future. There's no way you really can compensate for that loss, even if the person becomes a wage earner once they're out. So I think it is a very important point that whether any other state has done it or not, we should be clear that it's important to do so.
And I think it's also to note that the families incur costs themselves, right? Besides the income loss, right? They're putting money on commissary. They're sending money to their loved one. They're doing a lot of things, costs of calls and so on, transportation. And if they have to do that over 20 years, right, that certainly adds up. So I think that that's something that we should make sure to add to the justification while we're even looking at this.
I think
one of the
right.
recommendations. Yeah, I agree. Sorry. I was going to say one of the recommendations was for reasonable attorney's fees when the compensation is awarded. And we did have a brief discussion about some people can go and get compensation without a hearing after certain findings, but the majority of people have to go through a process that can look akin to a mini trial to meet the standard that they're deserving of compensation. So I would be in support of some sort of incentive for attorneys to represent people in this process. It doesn't come out of the person's pocket for having to pay for the attorney.
I would support that with the exception of the important exception is the automatic payment of compensation upon findings in court, which I've had the pleasure of representing somebody in, is truly automatic and does not need an attorney, and nobody should be compensated for that. It should not come out of anybody's pocket.
There's an additional thing I think we should address in the report, and that is, so clearly compensation is essential and important because the person, because of the wrong that was occurred to them and all the impacts that had. But I think right now, the way it's structured, beyond that it's too low, it's the state that has to pay for it. And the decisions, the wrongful conviction decisions, are on a county level. So if we want to have the that compensation be any kind of incentive for a county to be more careful about their convictions. And clearly all the discussion about the jury circumstance in Alameda County, there's a, one would, well, we don't yet know if or how many wrongful convictions resulted due to that. If there were some, then that's really, it should be on the county. So I think there should be some discussion about that, that compensation might be structured in a way where the county that made the wrongful conviction has to share in the cost so that there's some impact felt on the part of the entity that made the bad decision to try to affect future. So there's, maybe we have some ability to lessen those bad decisions.
I have a
generally
thought. Oops, sorry, go ahead.
I agree.
Oh, I was going to respond to Senator Skinner that I generally agree with that from an accountability deterrence perspective. But I wonder, we may need more information on this, whether that is going to deter counties from, you know, finding people were wrongfully convicted or pursuing those or conceding those cases, because it's going to bear financial, they're going to have to bear a financial cost around it. And I wouldn't want to, I'd want to balance those two competing interests before we made a decision on how to.
Yeah, and just to also make sure that we understand, the people who have who've committed negligence are liable in litigation subsequently. We're talking about cases where there's no negligence, everybody did the right thing, everybody, it would just happen to be the wrong guy, and it was an honest mistake on the police part, the prosecution's part, the judge's part, the jury's part. There's nobody who has acted poorly. They made a
Yes,
mistake.
but how, but Mike, I'm sorry to, how common is that where, I mean,
That I share your skepticism. I'm saying that also what is also very common is those people then brought into court on civil rights charges, and they are directly held liable. They are held liable. So now those are complicated cases. There are private law firms that litigate this quite aggressively, but that is how
yes, there
wrongdoers.
can be this other compensation based on, you know, you sue the city or the police department or the DA or whatever, but those aren't always, I guess to me, it's a principle that in our report, we should talk about it. And to Heidi's point, look, it may not serve as a deterrent, and it may, and we certainly don't want to structure it such that then say there's no action to increase the compensation, because by putting it on the counties, just, you know, this is something I know well as a legislator, it becomes then a local mandate, which then means that the state has to pay for it ultimately anyway. So, you know, we don't want to go there, except that it's worth it. Part of our role in doing this review is being that bully pulpit to point out these issues. And I think it's worth it to have that discussion in our report.
And I would also just ask, Chair Romano, as you're talking about the subsequent civil rights lawsuits, my understanding is that it's virtually impossible to hold a prosecutorial agency civilly liable due to prosecutorial immunity. So, I mean, obviously the police and others can be held responsible, but am I mistaken in understanding that it's difficult to recover civil rights in civil rights claims against prosecuting agencies, or if not impossible?
It's not impossible. I agree that it's difficult. I agree. My understanding, and I'm not an expert on this, and we can research this, is that almost always the negligence is on the part of the police department to begin with. We're not.
But it still comes out of the county's pocket. It's still a cost to the county.
And immunity is obviously litigated in all of these cases and hotly contested. That's my understanding. But to Senator Skinner's point, I still think that and to everybody's point, we obviously don't want to discourage claims of wrongful conviction based on this financial model. But on the other hand, if there is an agency that is responsible, it makes sense to debit their account. I have another hot button issue that I didn't raise, that I've just thought about here, that I wondered if people had reaction to. Should there be compensation for unconstitutional incarceration that is not innocence-based? Meaning, you
Yes.
were, okay. So a court has found that your punishment was cruel and unusual punishment, and you're freed. You're ineffective assistance of counsel, and you're freed. You're incarcerated in a violation of a statute, and you were freed. Should we propose that, should we at least consider that? Let me put it this way, because we're not voting on anything. Does it make sense for staff to research and perhaps develop a proposal that compensation should also include any deprivation of any unlawful incarceration?
I think staff should be encouraged to look into it and to see what they find. Obviously, like you said, we're not voting on anything, but I'd be interested to know what the potential remedies are. Obviously, I mean, in that kind of a case, we talk about civil rights remedies. I don't think that there are many, if at all. So, what if a person was incarcerated due to racial animus, right? That's not innocence. They're not able to be compensated for that under the current scheme, but they were not lawfully incarcerated due to errors from the state in a similar way. So I think we should at least research it and see what's possible. I understand that that would drastically increase the cost of these programs, but again, I don't think that that should be a deterrent for us to research this question, because, in other words, and if we don't, the individual continues, who's least able to bear the cost, continues to bear the cost, they and their family. So I think we should take a look at changing that balance.
All right. So you want to add that to your to-do list, Tom?
Yeah, I mean, I think there isn't that much to look into. It would just be saying to do that. I mean, I don't think there's models from other places or things like that. So it's
Well,
more.
I guess that's the
pure-
only question. Do any
Yeah.
other
No.
states or countries even compensate for unlawful just unlawful incarceration rather than actual innocence?
I think it's always linked to the incarceration as unlawful because you are innocent, and decoupling that. I'm fairly certain no one in the United States would compensate for that. And I think in part because there are concerns that it will make those claims a little bit distasteful to decision makers if they know it's also writing a check to someone who they think is guilty of a crime at the end of the day. But it's very complex.
I think that's real. I think that's real.
On that same note, there's, I think one really interesting example of this is felony murder, though. Someone is got their conviction changed because we've determined you no longer committed murder. They are innocent of the murder from a certain point of view, from a legal point of view. The compensation board has a regulation that says we consider the offense at the time of your conviction, not how it would be now. So those people are by regulation excluded from compensation. That might be a narrower way to look at this issue, where we've redefined a crime and the person is not, totally innocent, like I wasn't even there, but I think felony murder is really the only example of that, but it's a very potent one. And the VCB has determined those folks aren't eligible for compensation. And that might be a way to maybe take a first step into that world.
Can I make a counterpoint to that? So, I know that there are cases where folks are actually innocent, but through a settlement with the prosecuting agency, they settle on a legal resolution to the case instead of litigating the innocence claim, right? So, okay, we'll concede you had ineffective assistance of counsel, or there was a problem in jury selection, but we will not, and we won't have to go through a whole process around your innocence claim.
Or they're just willing to take a plea to a lesser included to get out of prison and save themselves 5 or 10 years of fighting, the
Mm-hmm.
exoneration.
And those people get nothing.
Well, they could actually under current law.
How do they get to that? Can you help me understand that?
You just have to go and prove you didn't commit the crime. You can say, I pleaded guilty for these reasons that we know are a thing that happened. Like it was either that or I had to stay in prison and fight the case for 5 years. But here's the reasons why I'm innocent. And if you can prove that by preponderance of evidence, compensation board would give you an award. I don't know if that's ever happened, but the law is written to allow that right now. And there's ways that could be done to maybe explicitly take account Alfred pleas or pleas to a lesser included offense, for those reasons. But the law would allow it now, technically.
I mean, and if we allowed for attorney's fees, and that would certainly incentivize people to take those cases.
Right.
I also wonder, is it permissible for prosecuting agencies to require a person waive their ability to go before a compensation board to litigate the question of innocence? Is that something that happens? And if so, is that something that we should address?
We did not hear that as a concern, but I don't see any reason why it couldn't happen. I wonder how many. Yeah, it wasn't something that came up in our research, and we heard about a lot of esoteric situations. Let's put it that way. But absolutely, that could be something that's happening.
I was
Okay.
going to make a quick follow-up to your point, Tom. Not that I'm not sure how I feel about the compensation for the felony murder, but if you're going to create that bucket, I'd also put the juvenile life without parole who've been resentenced just because their sentence was cruel and unusual under the 8th Amendment.
Yeah, that's an interesting one. Well, on the last point here is, and I think one other thing we heard today about it's much more of a technical issue than sort of these bigger policy ones. It's just these statutes really are a mess. I would not recommend looking at them. They really take a lot of time to understand what they're actually saying, and I think a general rewrite and a slight expansion to, if your acquittal comes via direct appeal and not via habeas corpus, you shouldn't be left out of this whole process, the other things that we've laid out and the staff recommendations, I think we should keep those as part of the mix too. Obviously, there isn't much to discuss about it, but I just wanted to flag that too. These things really should be a lot clearer.
Okay, moving to habeas claims of most, we started with habeas claims related to innocence, but we talked about habeas claims more generally as well. The first is to harmonize the standards for relief in any event, we talked about this idea that we create a consistent rule of what allows for relief based on wrongful conviction. And I think there was a proposal of a reasonable probability of a different outcome is what's in the staff memo. We also discussed clarifying the procedural rules for successive petitions and late petitions should not bar meritorious claims if, in light of evidence presented, a different result is likely. We talked about expanding post-conviction discovery and Brady obligations to include, to be explicit, let's just say, about favorable evidence the defendant should be disclosed, even, period, in all cases. We also discussed holding on to prosecution notes and transcripts for the entire course of somebody's incarceration. And I guess there was an explicit.
I think it was the entire file, not just the notes.
Yes, everything.
Right, okay.
Sorry. Prosecution notes, court file, prosecution file, public defender file. Everybody should hold on to everything. No document should be destroyed in any case. I don't know how to phrase it. During the course of somebody's incarceration. Period. With a particular flag to jury notes. I don't know if we need to call that out, but
I
let's
think
make
we
sure.
do, because it can't hurt. Let's put it that way, because people
Okay.
say they're privileged for a reason.
Well, we can say including evidence that might be considered privileged information. It has to be at least preserved. We'll fight another day about whether or not it's privileged. I mean, nothing should be destroyed.
Okay.
I mean, at least that's, I think, my tentative feeling, and I think that we should sort of begin crafting an idea around that. I think that those were the issues that we discussed. Tom, is there anything that I have omitted that you think that you need further direction on, as long as we're all here together?
No, I think that, the one thing, this didn't really come up in the
Oh.
discussion, but letting courts be able to dismiss cases instead of just vacating convictions. So, you don't have uncertainty about what's going to happen if the court's convinced that this shouldn't proceed at all, making that explicit.
So dismissing the prejudice, is that what you're saying?
Yeah.
All right. I mean, that was in the memo, but I don't think it was didn't come up in discussion.
That's right.
The other thing that we discussed today was the credit earning issue with Jennifer Schaefer. I think this is a unfortunately complicated issue. I hope that we can figure out a clean fix. I'm worried that we cannot, sadly. Unfortunately, Senator Skinner isn't here. I don't know if she thinks a 2/3 vote even is possible, but my tentative off-the-cuff reaction would be to see if we could get just identical wording to Prop 57 passed by statute and 2/3 vote
Why do you think the 2/3 vote is
to overcome any concern about ballot measures that might stand in the way?
I see. Okay.
I read it as a statutory interpretation case, the way she decided it, but we don't have to hash that out.
I just see it coming down the road. They're going to stop 3 strikers. They're going to stop if felony, excuse me, LWOP cases start. We should just put our foot down. Well, it should be unanimous, honestly, after Prop 57. I mean, I exaggerate, but
Yeah.
CDCR should do credits for everyone, period.
Mike, can we go back a little bit? I apologize.
Yes.
As part of the sort of favorable evidence discussion, we'd also talked about sort of how that would apply in Racial Justice Act claims.
Oh.
I don't know if this is the right time to keep considering that, or what the committee's thinking. But with RJ stuff, I think it's the law is so undetermined right now, and what's written looks really good, and we're figuring out exactly what it means through doing litigation. I guess I'm a little hesitant to try to mess with it anymore right now, honestly.
I think that should be something along the lines of favorable evidence shall include evidence of unlawful incarceration. We can say including violations, including but not limited to violations of the Racial Justice Act or whatnot.
Yeah, I mean, I like that, but I think one of the core disputes in the Racial Justice Act is around this idea of who's similarly situated. So, they will say, well, this is not you. I don't have to disclose it. You were born on a Wednesday. This person was born on a Thursday. Therefore, that
No,
kind of stuff. So,
I understand. We haven't even gotten a successful Racial Justice Act case.
Has
Based
this
on
committee taken up the Racial Justice Act? Have we had a meeting on that?
we proposed this retroactive application. I mean, we very seriously. I mean, its implementation is the tough part. It's a terrific act. The law is terrific. It's the application, and I think that maybe
I mean, could we take up the issue of putting a little more guidance teeth standards into the Racial Justice Act so it'd be more user friendly for people? I feel like right now no one really knows what to do with it, including courts, lawyers, incarcerated people. And if we flesh it out, maybe that's a recommendation the committee would consider making, to flesh it out, make it more user friendly.
I think that's an excellent idea, Tom. I don't know if it fits in our schedule for this year, if we need to postpone it to next year.
It definitely does not, given the complexity of it, and the fact that it's very much a moving target. I'm a little hesitant to. I'm worried that we would hurt more than help, honestly. But let's think about it for sure.
Maybe
I-
just gather information about how it's being used, who's winning cases, what standards courts are applying, because I don't know if that information is readily available anywhere.
No, it's not.
It's all in trial court opinions, I think, at this point, which is basically impossible to get easily. But and we did a little bit of that last year. I mean, a lot of it. So I think it would make sense to come back to it. And one thing we were talking about with staff too was there were some recent California Supreme Court opinions about what to do if your case is on appeal and you have an RJA claim. You're supposed to be able to basically stay the appeal and go back and litigate it. And the court said, not really. So that might be one area in particular that where there's been a California Supreme Court case saying something. I think that might be ripe for further whatever revision at this point. But point well taken. Obviously, the RJA is something we've actually made recommendations on in 2 reports, so it makes sense we come back to it. It's one of our perennials.
Perhaps,
I-
go ahead.
Yeah,
So-
I would like for us to have at least an informational item like the way you went over violent crime. Like, there have been this many cases that have, had
Yeah.
favorable rulings on these grounds. Like, I don't think that we need to have a full hearing on it, but I would like an update, if not this year, then early next year. I would also say that notwithstanding the ambiguities in the statute or issues that are being litigated, I think we should reference the RJA and the disclosure of favorable evidence or favorable findings, especially if the legislature is going to be taking up this particular statute. I don't think we should waste the opportunity to make sure that this is included until we have very clear standards on, similarly situated and so on, right? We can argue about that. But I think we should at least include it in the disclosure requirement recommendation that we make to the legislature.
Yeah, I concur. As long as we're very clear, it's including but not limited to, because it should be any unlawful incarceration. So it would be great to have an update as soon as we can, practically possible, Tom, about this, because I think it'd be a great service not only to this committee, but honestly to the bar who's litigating Racial Justice Act. I just had a long call this morning with the San Francisco Public Defender's Office. It's really scattershot as far as I can tell. And whether that's this committee, perhaps something that we can do at Stanford to try to unify it. Maybe this committee can, at minimum this year, recommend continued funding that Senator Skinner mentioned about post-conviction counsel. That's a real problem, whether that goes to public defenders or elsewhere. I don't know if there's anything. I sort of agree with Tom that digging into the RJA itself, along what Heidi suggested, I think is too heavy a lift for this year. But maybe we can brainstorm about something that we can do this year that would actually help nudge the needle in the right direction that isn't opening.
I agree with Priscilla. Like, the only way to know what to do with it is to gather information about how it's working and not working and who's using it, not using it. I mean, I think we have to use that as our starting point before we attempt to make any changes to it. So I'll second Professor Ocean's suggestion.
Agree. And Tom, I guess we'll put it to you about whether or not you can present something. When's the earliest you can present something to us? I'm not gonna put you on the spot now to do it, but
I mean, it's not for the next meeting, which is in 4 weeks. So,
okay. All right.
Only because the information.
Suffice it to say that we're all very interested and concerned about it. It's an excellent piece of legislation that has really not lived. It has not been implemented well. Maybe perhaps because it's not drafted well enough, and perhaps it's something that we can do. Or there's probably many reasons why it hasn't been implemented.
Yeah, yes.
All right. Anything more on this before I move on to credit earning? All right. The last thing we talked about was the credit earning issue with Jennifer Schaefer. Again, I think that I hope that there's an easy fix. I fear that there is not. But let's try to make a proposal that addresses this issue. And this is time sensitive to people who are truly that we already know are unnecessarily incarcerated, and who have served an extraordinarily long time to begin with. And millions of voters of California have voted to give CDCR this authority, and I think that should be considered as well. Any last parting thoughts or instructions or directions to staff? Let me say before we move on to public comment that Rick, Joy, Tom, you guys have done an awesome job. The memos of this week again were really extraordinarily helpful. So thank you. And I know that we're just piling on work on you in the end of the year, and it's in some ways it's our crunch time. So thanks in advance, and thank you for everything you've done for yet again another great hearing today.
Thank you, Mike. Unfortunately, I have a few more slides to show on follow-up from the last meeting. So I hate to be anticlimactic, but we'll go quick. Don't worry, folks.
Go ahead.
Okay, these are quick. So, our last meeting was very much about crime, prevention, disruption, intervention. We came away with basically proposals for two things. The first is prosecutor-led diversion for gun possession. Right now, judges can offer diversion for essentially any misdemeanor offense, which includes a lot of gun possession offenses. Nothing says prosecutors can't do it even for felony gun possession offenses or misdemeanor ones, but from what we can tell, they aren't. There's a good program in Minneapolis that's been studied that shows big reductions in recidivism for folks who go through it, and they also have their conviction dismissed. And so the proposal here is modest but important, which would be to create a penal code section that would allow prosecutors to offer these programs for folks who are charged with misdemeanor or felony level gun possession charges. So pretty straightforward, I think, but any questions or concerns from anybody? All right, great. Then we have two on civil forfeiture, both which are also, I think, modest but important. The first is to exempt amounts below $10,000 from civil forfeiture. So you could still forfeit them with a criminal conviction, which would increase the due process convictions because you'd have an attorney and there'd have to be proof beyond a reasonable doubt of the money's connection to the offense. And why $10,000? That sounds high. And in fact, 70% of completed forfeitures were for less than that for drug cases last year, but that was less than 10% of the total money seized. So even though it's a lot of individual forfeitures, it's actually not a lot of the money seized. And anyway, 50% of those were done for criminal conviction anyway. So what this would do is this would give due process to those lower level forfeitures that really, I think, present the most opportunities for folks to have money taken from them in a way that doesn't seem appropriate, because you'd have to satisfy the higher conviction of a criminal procedure. Minnesota has done something similar to this, but their amount is lower, and 4 other states don't allow civil forfeiture at all, would similarly allow forfeiture only with a criminal conviction. So that's the idea, $10,000 floor for civil forfeiture, but still allowed in criminal cases. And then the other forfeiture proposal is to expand what law enforcement can spend some of their money on, which is to include crime victims. So about 10% of forfeiture money now has to go to combat drug abuse and divert gang activity. As we discussed last time, it's not a lot of money. It was about $4 million in 2023, but you could expand it to include crime victims and, get that money perhaps to a few additional places where it would be helpful. So those are the ideas. Any questions, concerns about any of those? If not, we'll put them in the hopper and bring them back next month when we have the list of all the recommendations for the annual report.
Anyone have any thoughts? All right.
Great.
Thank you, Tom. Thanks to the committee again. No, I genuinely appreciate it. So much of the work that I do here is really done behind the scenes by the committee staff. And I appreciate you making me look good and all of us look good and all of the work that we do for the state. So thank you guys. I think we're the best agency in the state.
Best agency of less than 10 people.
Yes.
we can have weight classes.
Pound for pound, we are the best agency.
There you go.
All right. Tom, do I now have leave to go to public comment?
So granted.
Oh, thank you. We've now reached the time for public comment. For those on Zoom, to get in line to comment, please select the raise hand function. If you're calling in, you can hit *9. Please note that this meeting is being recorded, and if you make a public comment, your name and or phone number may be displayed as part of that recording. If you're watching this meeting in person, is there anybody, Megan, with you?
I don't think I think she would have told us.
Okay. We'll take a minute now to see how many people are waiting to comment, and based on that, I will see how long each person has to make their comment. Please note that the committee also accepts and actually prefers public comment in writing. That comment can be emailed to committee staff whose emails are on the committee webpage. Let me
Got
see.
2 folks with their hands up already. You want to get rolling?
Great. Well, sure. Tamiko, let's do 90 seconds, please. Tamiko, how are you?
Hello, hi. I don't know how to take my good evening. Wow, it's been 5 hours almost. My name is Tamako
Oh,
Shine.
excuse me, Tamiko.
Yeah, okay.
Oh.
And I'm a cultural anthropologist, founding director of Asian People in Prison Human Rights Campaign. Before I forget, I want to say real quick, you always talking about the Racial Justice Act. We do have a liberation lawyer with us who lives in California. She's going to be doing her PhD exactly on that. She's been interested in that for years. Just want to put that out there. Her name is Attorney Maya Garza. But I was going to speak to, we have a gentleman, the last time I attended one of these meetings was about 3 years ago, and it seemed like the community got to speak much earlier. This has been, wow. And I was going to speak about Michael Dora, who's been in about 40 years, always claimed his innocence. And I thought I could ask questions to the guy from the Criminal Conviction Integrity Unit about just the process. But I did want to mention, just observing the commission today, I don't see anyone that's a part of the members who is from grassroots, no one that's been system impacted, and I don't see anyone that's part of the members under 40. Also, I don't see a lot of community input. Definitely some type of strong statement should be made with the recent ruling Judge Rockwell did from this commission about that, because it's very serious as far as holding up, delaying people who already have served many decades in prison. Our organization, we work across the nation, national and international, to get elderly people out of prison. And we also engage in legal mitigation work. I practice legal anthropology. So I study processes and different things such as this. So I think that was mainly my contribution. Also, I want to say this is a decarceration era. The plans, the recommendations, and your reports you have done, you cannot do this without community input. I do not see enough of that with this committee. Like I said, I've been on 3 years ago, I've been tracking you. And you got to make stronger recommendations to me from what I've observed. California is one of the big states, one of the highest ones incarceration in the states, and there's much work to be done. And so something has to change with this committee, this commission, and it has to be some type of change of the members that's on here and more input from the community. But this is a decarceration era. Things like restorative justice, transitional justice, reparative justice needs to be implemented, and that link needs to be instituted more in your suggestions and recommendations. That's all I have for today. Thank you so much for giving me the time.
Thank you, Tamiko. I hear what you're saying, and I hear you saying that that perhaps I'm part of the problem myself. We work very hard on this, including to hear as many voices as possible. I agree with today's hearing was almost all attorneys. Were they all attorneys? In any event, but we work hard to make sure that we have voices from across the spectrum. Today was I think more of an exception than the rule. But I do take what you're saying. I do not have power to appoint who's on this committee. That's not my role.
But you can make the recommendations to have more of the members, and that's where it is going now. These types of committees is that people have been system impacted. They are now making these decisions. They are now the ones with the solutions. Like the guy earlier who was exonerated, he could be on here. So we got to change if we're going to go into decarceration era, which is where we are right now. You got to catch up to the rest of the world.
Well, let me tell you, I share that, and I assure you that there's no state committee in the country that has been recommended more laws to reduce incarceration than ours. I think we really stand apart in that. But I do hear what you're saying, and keep on pushing us. As
I will.
Okay.
Thank you.
Thank you. Crispy, speaking of somebody who keeps on pushing us, longtime listener, regular caller too. Good to hear your voice.
Hi, this is Crispy, and I will read comments from people incarcerated in California state prisons. So Tamiko, this is the way that we get people from the inside into this meeting, because I've been trying for a long time. So this is how I do it. Ronald Montez from California Men's Colony. My name is Ronald Montez. I am a lifer. I have a great work ethic with maximum moral conduct and discipline free over 8.5 years now. Please fight to keep our conduct credits intact. Thank you so much and have a great day. Also, wrongful convictions topic. There's thousands of men, women who should have been sentenced to a mental health treatment facility, but they're here without proper treatment and should be sent to a state hospital. Thank you. Jasper Stallings, Valley State Prison. He's also a senior inside organizer with Initiate Justice. The criminal justice system needs to be looked into on a microscopic level because far too many people are locked up in California's state prisons. Some are completely innocent, but yet have been convicted and served prison time, causing a critical gap in many productive years of someone's life. Compensation is a must. If it is proved that said individuals have been wrongfully convicted based on a variety of circumstances or misinformation being presented at trial. I asked Mr. Trigilio, Mrs. Harris, and Mrs. Shaw to go deeper on more of these situations. It's been an honor to share this, and I look forward to seeing some improvements in this area. Thank you. And thank you to the committee. I appreciate the work that you're doing.
Crispy, thank you. Thank you to everyone. We do try to get voices of incarcerated folks. Crispy has done it, if not every single meeting, close to it. She's read letters from people inside, so thank you for that. We've had people who are currently incarcerated. We worked with CDCR to have had voices, and we'll continue to work on that as well. Thank you for continuing to push us and remind us of those obligations. All right. Thanks everybody for attending today. Our next meeting will be on October 11th. We've covered a lot of ground today and done a lot of great work, and for that reason, I'm out. Have a good evening and weekend, everyone. Thank you. We're adjourned.
Thanks, everybody.